Good evening, everyone, and welcome to our February 2023 Right Set Night session. I'm Sharon Doe, a middle and high school science teacher from Richmond County, and I'm your current GAE Vice President. For those of you who may be joining us for the first time, we started the Right Set Night session back in July of 2020 with issues around COVID. And boy, were there a lot of issues. But at GAE, we pride ourselves on keeping our members informed. We know that when our members are informed, they can make better decisions about their own lives and about things that impact the children that they come in contact with every day. So some of the topics that we've informed our members about during these Rights at Night sessions are social media and the First Amendment rights, the teacher's retirement system, and strategic waiver school systems. If you're interested in seeing any of the information that was presented in past Rights at Night session, they're all on our GAE YouTube channel. And you can go back and watch any of these topics that you're interested in. We are recording this session this evening, and it will be placed on our GAE YouTube channel as well. So you can share it with your colleagues or with members who are not able to join us this evening. So this evening, our topic is teacher contracts. I know that many of you have been issued your teacher contracts this year. Some of us are still waiting on our teacher contracts for our 2023-2024 school year. So it's right on time that we have this topic to share with you. At this point, I'm going to introduce to you Wanda Lynn and Tyra Donald. They're two of our wonderful GAE UniServe directors who work very hard every day to protect our members and to help them through the process when there are legal issues concerning their rights. Wanda, Taya, I turn it over to you.
Good evening, everyone, and welcome. Tonight's session will be over employment contracts, and I'm going to pull up the PowerPoint very quickly. Thank you, everyone, for joining us. Okay, just want to make sure everyone can see. Okay, this is GAE Legal Services Georgia Educator Employment Contract Session. We're going to try to answer common questions that you may have about your teacher contract. And I do want to thank my colleague, Taya Donald, for joining me tonight. I did ask her to join for support and to jump in whenever she felt like she could add something, which I'm hoping is often, Taya. So first of all, we're going to talk about our legal services, how, when you ask members why they join a professional organization, many times they say for what? And jump in at any time. For legal services, correct? So what do you get for your legal services? And employees feel that they need legal services now more than ever. So let's look at what we get. Our GAE Legal does not have a predetermined cap on fees. And as you can see here, we have with our liability protection, $1 million liability with a $3 million aggregate, $3 million attorney fees and cost with a $9 million aggregate. And then for the employment and certification defense, if you notice, there's no predetermined caps and your fees are covered win or lose, which makes us the most outstanding organization with legal services in the state of Georgia and for the nation for that matter. Okay, I'm going to move my little down here. Commonly asked questions about teacher contracts: to waive or not to waive. I'm sure many of you have heard of waivers. If not, we'll talk about waivers just a little bit. I know one of the other sessions on Rights and Nights was about waivers, and we're going to touch on that a little tonight. But when you're thinking about your contracts, you always need to check the waiver status of your school. And when we talk about waivers, back in, I believe it was 2015, correct me, Taya, if I'm wrong. What was that in 2015? The states were given the flexibility to choose whether they would be a traditional model, a strategic waiver school system, or a charter school system. And within these models, they had the ability to be flexible with certain Georgia codes as to increase student achievement. So as it stands right now, and I'm going to go ahead and move to the next slide because I like to be able to see a visual with mine. With charter systems, we have 48 charter systems. Strategic waiver systems, we have 130. And then there are two traditional Title 20 systems, and those are the two in Georgia or Webster County. And what's the other one, Taya? It's in DeKalb. Gwinnett.
Beaufort City schools.
Beaufort City. Let's see. I want to go back. And strategic waiver, just wanted to go back to this. Strategic waiver schools have the right to pick and choose education laws that the school boards decides that would they could waive in exchange for soaring student achievement. And the charter schools, all Title 20 education laws, with a few exceptions, are granted complete flexibility so that the student achievement will soar. This is all in the name of increasing student achievement. And again, there's the map, 48 charters, keeping in mind that they're very flexible in what they can waive. And then the strategic waiver systems have selected codes that they are waiving in order to raise student achievement. And if you look in this section, I have posted the link here, and Taya's going to put that in the chat too. It's where if you are a strategic waiver school, you can go to the link, click on your district, and you can find everything that your district has waived, which is important when we're talking about contracts. Okay, let's get back to the basics. What is a contract? A basic common law elements of contract. Offer is when you receive the contract. You are presented with an offer. Acceptance is when both you and the superintendent of the schools sign the contract. Consideration is the compensation in your contract, the compensation for your employment. Also, enforceability. It's binding when accepted by both parties and is enforceable by Georgia Code 2-20-211. Title 13 of the Georgia Code codifies basic concept. A contract is an agreement between two or more parties for the doing or not doing of a specified thing. Teacher contracts are governed again by Education Statute 20-2-211. An offer. The offer, as I said, is when you receive your contract. It's not your letter of intent. The letter of intent is not a contract. It's not considered a valid contract. often in a school district, everyone receives a letter of intent and everyone signs it, but just because they sign the letter, or just because a person signs the letter of intent does not mean that he or she will be offered a contract. Contract review period and 10 days per code 20-2-942. But remember when we talked about the waivers, this is one place where you can check to see if that has been waived, because it could be, I have members calling from my districts and to ask, well, I thought we had 10 days. Well, it could be that your district has waived 20-2-942 and you need to get in your contract sooner than the 10 days. If in question, if you have been asked to get in your contract earlier, do so, or contact your UNISERV director to ask them if you have extended time. But if you do not get in touch with your UNISERV director, please follow the request by your district there, because it could be that your district has waived that statute. Okay, my computer froze there for a minute. I hope y'all are still with me. What is a contract? Teacher contracts are governed by an education statute. Okay. Acceptance. We talked about the offer. What the offer is not. The offer is the contract. Acceptance, again, is your signature and the superintendent's signature. Okay. Also, the recommendation by the superintendent must be accepted by the Board of Education. And the same can be true for resignation or you rescinding your contract, or your contract being rescinded. Commonly asked questions about teacher contract. About your teacher contract. Always read your contract before signing it. There is no statute defining, limiting how early the contracts must be offered. Georgia law requires that contracts shall be complete in all terms and conditions, including the amount of compensation to be paid during the ensuing school year. The statute does not require contracts to state the specific position or school location. This is important. I have members call me and say and with the question of, well, I thought I was going to be assigned to Veterans Elementary, but I was assigned to Northside Elementary, but my job changed to Northside Elementary, where your contract does not specify a certain position or a certain school location. So just keep that in mind. Commonly asked questions about teacher contracts. School systems must offer written contracts for the following year by May 15th. Remember, there's not how early, but there is a date which they must offer the contract by, and that date is May 15th of the current school year. The superintendent must provide written notice of non-renewal postmarked by May 15th if he or she will not be recommending the educator for employment for the following school year. Okay, and if you notice this, it says the superintendent must provide written notice of non-renewal postmarked by May 15th. Okay, they send this out certified mail May 15th. However, if an employee doesn't get that or doesn't get that email, or not email, but we'll call it snail mail or U.S. postal mail.
Yes.
Pardon me?
Certified letter.
Yes, they will send it out certified. Thank you, Taya. But they will send it out certified. And just because you don't take it out of your mailbox doesn't mean that you're off the hook, because all the superintendent has to provide is written proof that he has actually sent that out and it is postmarked by May 15th. So if you think that you're going to be receiving a letter of non-renewal, you need to check your post office box or your mailbox. Look out for that non-renewal so that you can contact your UniServ director and you can see what are the next steps that you need to do to address your non-renewal.
Wanda, we have a question in the chat.
Okay.
The question reads, so is it my understanding that a contract should have a salary amount for the ensuing year stated? I guess they're
This-
asking, should the contract have a salary amount stated on the contract?
No, the salary amount does not have to be stated, but what does need to be stated is your level of your certificate and the years of experience, so that they will know where you'll be placed on the pay scale for the next year. Because when the contracts go out, a lot of the times the budget has not been adopted yet. So the compensation for the next year has not been determined to go into that contract. Does that answer the question? Does that make sense?
If I can chime in.
Okay.
Because it could look different ways. Hello, everyone. I'm Talia Donald, UniServ Director for DeKalb, Decatur City Schools. It could have I've seen a contract with a daily rate, your current year's salary, as Wanda stated, it could have your salary step on it. And so it could look of various ways. If you could go back on the slides, Wanda, back to what should be included in the contract.
Okay, let's see. Including the amount of compensation. It doesn't have to be a dollar amount.
Yes.
Where that is, what it could, because the dollar amount for the next year may not have been determined by the state budget. It will just have on there, perhaps your, like I said, your certificate level and your years of experience as to where you might be placed on the salary scale.
We've seen it done many different ways.
But it does have to address that compensation in some way. Whether it be a dollar amount, as I think Ty, you said that DeKalb actually does a dollar amount.
They do, and I've also seen them put a daily rate
Okay.
instead of.
So it may be done in different ways, but it must include compensation in your salary.
Yes. Okay.
Does that help? Okay. Let's see. Okay, this is more about non-renewal. If an educator does not receive a written notice of non-renewal by May 15th, then the contract is automatically renewed for the following year unless the educator notifies the Board of Education in writing no later than June the 1st of their intent not to accept employment for the following year. Okay, and I've had members who have been told that they will be non-renewed or that he or she will be non-renewed by the district. Okay, my advice in some of those cases is not to go to the district to say, not receiving a non-renewal letter, when will I be receiving that? Because as this says, if you haven't received that letter, or if they haven't sent that letter by certified mail, the proof is on them that they sent it, not on you that you received it. However, if you have not received one, or let me correct that. If they have not sent a letter by May 15th, postmarked by May 15th, then you have a contract for the following year. So May 1st, don't go asking about where your letter is, because it is assumed that you have a contract for the following year. And in one case, I know, and it was in one of my districts, the person was not notified. So the following year, that person showed up on the first day of school at the HR's office to be placed for a position. And she had a position for the following year, even though she was told that she would be non-renewed. The district dropped the ball in sending the non-renewal letter. So that person had the opportunity to work in the district another year and in a different school. So she was able to work somewhere else and continue to work in the district because she was not in the same school that she previously taught in. Okay, the PSC will not sanction a certificate if your resignation is submitted prior to June 15th. Okay, that's very important. The PSC will not sanction your certificate if your resignation is submitted prior to June 15th. However, as stated in the letter before, you need to notify your district in writing no later than June 1st of your intent not to return, not to accept employment for the next year. But this has two dates that you're playing here with. But to be safe, it's June the 1st. But to know that the PSC will not sanction your certificate if your resignation is not submitted prior to June the 15th. The law also requires superintendents to provide any teacher whose contract was not renewed upon a written request, a written explanation for failure to renew their contract. And our Director of Legal Services, Mike McGonigal, is the person that prepared this presentation. And as he says in the next sentence, be careful of what you ask for. Make sure that you're ready to receive that explanation of why you did not receive your contract if you ask for it. Because it could, you may not want a paper trail of why they did not renew your contract. And again, always speak with your UNISERV director.
Wanda, can I chime in?
Yes.
Yes. Just to give a little clarity about the June 15th date. As you notice here on the slide, it says that the PSC breach of contract guidelines number 6. On the PSC's website, they do have this document that will give an explanation as to what you could receive a clear release for as it relates to a request from a release of your contract. It also will give some explanation about the June 15th date. I encourage you to take a look at that document. I know this may be on our website as well, as we've shared these guidelines previously in many of our presentations around contracts. What it means to be sanctioned, there would be no sanction, means that the district would not take action against your certificate if you were to resign prior to June 15th. If you resign after June 15th and you do not meet one of those stipulated reasons on their guideline sheet, it is a possibility that the PSC could sanction your certificate for breach of contract. So it's very important, if you like to get out without having to meet any stipulations, that you just do it prior to June 15th. Many school districts will allow you to reapply if you change your mind at a later date. So it's just better safe than sorry if you're kind of in limbo about what you want to do. You definitely don't want the PSC investigating you in your certificate as it relates to a breach of contract. So as Wanda stated earlier, if you have any questions, please contact the UNICEF director in your area.
Thank you, Taya. And Taya, do you want to put the link up for the PSC? I'm sure that most people have that, but if you want to.
Let me work on that. Thank you. Give me a second.
Okay. Just know that will be in the chat so that you'll be able to look at that as well, to review that. Okay, wait a minute. Okay, commonly asked questions about teacher contracts. For educators that acquired fair dismissal due process rights, the notice of non-renewal must be delivered by certified mail. It must inform the educator of the local board's intention not to renew the contract. It must contain a conspicuous statement of the educator's due process rights, and it must be signed by the superintendent. Okay, after receiving this notice, by law, the educator must respond within 20 days after the notice was mailed to request a non-renewal hearing. If you notice, it says within 20 days after the notice was mailed. Again, and what was the deadline for the postmark was May 15th. All teachers, regardless of whether they have acquired due process rights to a non-renewal or demotion hearing, have a right to hearing for termination or suspension without pay. Again, all teachers, regardless of whether they have acquired due process rights to a non-renewal or have required due process rights to a non-renewal or demotion hearing, have a right to a hearing for termination or suspension without pay. But always check your local policy, because remember, when we stated about charter schools, if you're in a charter school district, the charter schools can waive almost anything. We've had some issues with some charter schools and due process and the due process rights. Okay, what is tenure? Okay, if you notice, we've used due process rights. The word tenure is not contained in Georgia's Fair Dismissal Act. A teacher who accepts a school year contract for the 4th consecutive school year from the same local board of education may be demoted, or the teacher's contract may not be renewed only for the reasons set forth in section of Code 20-2940. So if you have signed a contract for your 4th year in one district, for the 4th year in one district, you have received due process rights. However, I do want to say, when you move to another district, after you have due process rights in one district, when you move to another district, you will lose those due process rights until you sign the second the second contract in the new district. So if you move from district to district, understand that it's important that you stay in a district 4 years to get those due process rights before you move to another one. And then when you move to another one, you need to stay that second year to regain those due process rights. Okay, and I have this question a lot. How do I get out of my contract? An educator must obtain approval from the superintendent in order to be released from a contract or resign pursuant to district policy. You should refer to the contract for specific terms and always check your local school board policy. And if you are considering resigning, make sure that you check with your UNICEF director, because you do not want to resign and just leave your job, because that will be considered abandoning your contract and is a reportable offense to the PSC. You want to request to be released from that contract and get permission and to be released from the school board. Should an educator leave the school system without obtaining a release, the Professional Standards Commission may suspend their certificate for 90 days for breach of contract. Just as I just said, I jumped ahead of myself. Code of Ethics Standard 9. Unsurprisingly, your school district cannot waive the Code of Ethics. Just keep in mind that there's many things that the districts can waive, but they cannot waive the Code of Ethics.
Wanda, we have 3 questions in the chat.
Okay.
So the first one says, so we don't get rights for 4 years? ? So they're
You
asking,
do not have, okay.
they're asking if it takes 4 years.
It takes 4 years to get due process rights, to gain due process rights.
And the next question says, what are the benefits of the due process rights?
Okay, as stated with the due process rights, if they say if you've been, after you've signed your 4th contract, you're working in a district, and there may be, it may not be a performance issue, but there may be, say, a personality issue after those 4 years, and your principal has recommended you to be non-renewed. Okay, if you have due process rights, you can appeal that letter of non-renewal, and you can have a hearing in which you present your evidence that you will be a good candidate or continue to be a good employee within the district. And GAE will provide representation at that hearing for you. But remember, if you are having issues during your school year, in your classroom, as far as, I call it, sometimes my principal is picking on me, or my principal is, I can't do anything right, start documenting what's going on. Because when you get to the point that you need an attorney, you need to be speaking with the UNICEF director as well during this year, because what you want to do is make sure that you get your documentation in the event that it does go to an attorney because of a non-renewal, that you have your evidence in order, because the attorney can only represent you on the evidence that you have gathered and documentation that you present. So that is very important. So as far as the due process rights, it means a lot. We almost lost due process rights in 2000, I believe. No, what was it? It was with Governor Barnes, I believe, was going to take away our due process rights. And GAE fought very hard for our educators so that we could regain those due process rights back, because we do feel that that is very important. You know, after 4 years, you have worked hard to get those due process rights. We want to be sure that our members are protected in that way, because it does give you the opportunity to be heard sometimes when you feel like the situation is not fair. or you have not been treated fairly and that you've been non-renewed after, just after a bad year. Also, in the event of suspension without pay or termination or termination without pay or during the school year before a non-renewal, if there's an issue with that because of due process rights, you have the right to a hearing. And this is for contracted employees. Taya, is there anything that I missed in that?
Yeah, I just want to reiterate that the benefit of having due process rights as a contracted employee is that if you were to be non-renewed, you have a right to a hearing. Where if you do not have due process rights and have not gained tenure, then you are considered an at-will employee. You do not have a right to a hearing. So it is a benefit to gain your tenure, which is considered to be due process or fair dismissal rights, because that will give you an opportunity to have a right to a hearing if you were to be non-renewed.
Okay, last question on the waivers, waiver teachers. This is the question about a specific type of educator. And it says, are waiver teachers who have been in the waiver for 4 years also eligible for due process?
Wanda, would you like for me to take that one?
Yes, please.
Yes, if you are a waiver teacher and you hold a certification with the Georgia Professional Standards Commission and you have offered a contract, then yes, you would be eligible for fair dismissal rights. I think there's another question there. Dr. Doe, you want me to go ahead and read it?
Oh, the question says, am I correct in believing that in Georgia, you can audio record a conversation without anyone else's consent as long as you participate in the conversation?
Yes, that is correct. Georgia is a one consent state, meaning that as long as you're a party to the conversation, you can record without disclosing it to anyone else.
I would like to add to that. If your administrator, or if the person does see that you are recording and ask you to stop recording, you should stop recording so that you will not consider it to be insubordinate. And you should take notes. Anything, Taya?
Yeah, I would just say that it is my advice that if you do plan to record, that you keep that to yourself and, you know, put it in your pocket, in your bag, whatever the case may be. Because if you feel like you need to record, that's for a reason, and you want to be able to capture the conversation in its most honest, true form. So if you do plan to record, you do have a right to do that without disclosing it. So you might as well just not say anything or even put the recorder out on the table, because you could be asked to not record the meeting.
Okay. Are those the questions, Dr. Doug? Have we answered the questions? Okay. Okay, commonly asked questions about teacher contracts. Breach of contract occurs when an educator fails to honor a signed contract with a school or school system by resigning in a manner that does not meet the guidelines established by the Georgia Professional Standards Commission. And again, I think Taya was going to pull up something that referenced that and place it in the chat, the link.
It is in the chat, Wanda. I I have since copied it and reposted it or into the chat again for those who may have missed it the first time.
Okay, thank you. So if you need any additional information with that you can find that in the chat. The PSC will not sanction a certificate if resignation is submitted prior to June the 15th. A common problem, sometimes when you submit your resignation, the district says until a suitable replacement is found. How long is that? That is a question that's always asked. How long does it take to find a suitable replacement? And will the accepting district accept a resignation, or do they insist on a release from your district? And that will be up to the district, the new district that you've received your contract in. For example, if I'm leaving Bibb County and I'm going to DeKalb, and I submitted my resignation prior to June 15th. Okay, I've submitted a resignation because the PSC will not take sanction against my certificate. Okay, they're not going to do anything because I've submitted a resignation and that I haven't been released, but there's not going to be any action taken against my certificate. But will the new district accept that I turned in a resignation, or will they require that I receive a release from my contract? Is DeKalb going to allow me to come if I haven't been released and I've only issued a letter of resignation? That would be something that you would want to check. Say if I would need to check with DeKalb and to find out if I were going from Bibb to DeKalb, to find out if they were going to accept a resignation over a release from the district, over a release from Bibb.
And Wanda, just to give
Yes.
clarification on the difference, instead of release typically is something in a letter form or email from your current employer that says that you've been released from your contract. Some districts want to see that actual email or letter versus you just showing them your resignation form or an email where you've resigned from the district. So it is my recommendation that you obtain something from the school system that shows or states that you have a clear release. Like we stated, though, some may not require that. They only want to know if you've resigned, especially if it's prior to June 15th. And sometimes time is of the essence. You don't have time to wait for your current employer to send you all of the separation notices. So if that is the case, and that employing district will accept the resignation, then you can move forward at that point. After June 15th is another story, because at that point you are subjected to possibly being reported for breach of contract if you don't meet all the eligibilities for a clear release. That's why it's really important to work with your UniServ director after June 15th, so that way we can determine if you meet one of the eligibility stipulations, and that is in that document on the PSC's website. For breach of contract, it does state those stipulations, and they are if you're resigning due to a personal illness, a documented personal illness, a documented family illness, if you are receiving a promotion within the field of education, and that's typically not in money, but position or title, and you may have to provide documentation for that as well, such as a job description, and so forth. And then if you're moving out of the commuting distance for a valid reason, such as taking care of a immediate family member, following a spouse who is relocating for a job, or something to that nature. So those are mainly the 4 reasons that would get you a clear release after June 15th.
We have another question in the chat, and it says, why is the school finding a replacement our problem if we resign properly?
Some school districts will state that they can't release you until they find a suitable replacement because you've signed a binding contract with them. So you are already in a contract, a binding contract. So at that point, they feel like you need to give us the opportunity to find a replacement for you before we can let you go. So we don't want to let you go and don't have someone in the position. However, in some cases, we will say that the district can't hold you hostage. Sometimes they will try to hold you hostage where it looks like it takes weeks or months to find a replacement. So in those cases, they may state that to you. That's why it's important to work with the UNISERV director because every situation is different. So definitely, if you plan to resign, contact your UNISERV director so that we can go over all of these scenarios with you. There's one question here that says a contract is for a single school year. Yes. Contract is a year-to-year contract. Wanda, I think that's all for the questions.
Okay, so we'll continue with some more commonly asked questions about teacher contracts. The annual performance evaluation, PSC rule, unsatisfactory, ineffective, needs development, or the equivalent. Educators with 2 unremediated, unsatisfactory ratings in the preceding 5 years are not eligible for renewal. Again, this is looking at your evaluation, your annual performance. Educators with 2 unremediated, unsatisfactory ratings in the preceding 5 years are not eligible for renewal. And there is no appeals process for this at this current time. We have been working to get some new language with that, and it's my understanding that there's a new instrument right around the corner that some of this, we're hoping that some of these issues will be changed. What is GAE doing to fight back as far as liquidated damages? And Taya, this is the DeKalb DeKalb schools situation. If you would take this, this is Taya's local situation that in which liquidated damages, we want to sue in that. And I'd like for her to share that with you.
Just one quick question, Wanda, was there a slide prior to that gave an explanation of the liquidated damages?
No, I don't think so. Let me go back. No.
No, okay.
No. Okay. I mean, I can explain what liquidated damages are, or you can.
Well, listen, I can go ahead and do that.
Okay.
Liquidated damages is a monetary amount that could be included in your employment contract. Liquidated damages is the amount that a district would deem as necessary to replace you as an employee. It is illegal for them to use it as a penalty, which is the case in DeKalb. DeKalb decided to include liquidated damages in their contract some years ago. It was $750. It was fairly new to the contracts in DeKalb. As educators started to resign, the district, of course, then implemented the liquidated damages. for the employees to pay in order to get out of the contract. But they coded it as a penalty in the letter. GAE filed a lawsuit, we won. DeKalb has since taken the liquidated damages out of the contract. They have not had the courage to place it back, which is a good thing. So it's very important, as Wanda stated earlier, to read your contract before you sign it. It could include liquidated damages. That is a monetary amount that could be assessed to you if you decide to resign or request a release from your contract.
Okay, and this is another case involving liquidated damages in Griffin Spalding, where there were two of our members who were penalized after they found jobs in other school systems. And this was settled positively. But if you notice the wording, it says to penalize. You can have liquidated damages in your contract. Most contracts do have liquidated damages in there during these days. However, if you receive letters or if they send something to you and they refer to these liquidated damages or as punitive, are they penalizing you, then that is considered liquidated damages cannot be punitive. They might convey something associated with the district fund and replacement, and that's it, but the liquidated damages are not designed to penalize employees for punitive damages only, which that's the wording in the contract. You have to pay very, very close attention to the way wording is placed in the contract and to letters that you receive after you have decided to leave a district. If you are trying to get out of your contract and you're asked to pay the liquidated damages, you want to pay very close attention to the wording that is used, because if in any case it's used in a punitive way, then that is unlawful. Also, over this situation, and I was UNICEF director in Griffin Spalding at this time. After we had filed the suit, the school district threatened to take away our payroll dues deduction. So we actually had to go in and contact every member and set up a way. We were in the process of doing that. However, we also contacted the school board, and they were not happy because they were not informed that the board was not informed that the district attorney had determined that the payroll dues deduction, GAE's payroll dues deduction, be taken away. So we were allowed to continue payroll dues deductions when we were supported by the local board. And NEA and GAE filed a federal suit in violation of free speech and associational rights, and that was settled favorably.
Wanda, we have one question.
Okay.
Here in the chat. It says, can you please define unremediated? I do believe that was on your slide as relates to certification renewal.
Okay. Okay, that's when you've received two unremediated satisfactory ratings where there's shown no improvement. Is that not correct, Tanya? Where they had the preceding 5 years not eligible for, that you're not eligible for non-renewal.
Yes, what does unremediated mean?
Unremediated means that you haven't remediated those satisfactory ratings. Those satisfactory ratings you haven't received satisfactory ratings, isn't that right?
Well, I'll break it down just a little bit.
Okay,
If you receive an unsatisfactory rating that is a needs improvement or ineffective on your summative, teacher key summative, it is required by the Georgia Professional Standards Commission to be reported. They require all school districts to report teachers who receive an unsat, be it needs development or ineffective rating, overall rating on your summative. The school districts are not required to report proficient summative ratings, only needs development or ineffective. So that is how that is reported to the PSC. If you receive 2 in a 5-year renewal period, you will not be eligible to renew your certificate. In order to remediate those, you either have to successfully complete a professional development plan, which is required if you receive a needs development or ineffective rating. A professional development plan or professional remediation plan is required. If you successfully complete that the following year, then you would have remediated the unsatisfactory evaluation. Or if you receive a proficient evaluation the following year, that can be considered a remediation of the prior year's unsatisfactory evaluation. Now, the key is that if you have received the unsatisfactory evaluation, the following year successfully complete a PDP or remediation plan, or receive a proficient summative evaluation the following year, you as the employee or educator will need to request that school district you're in, to report that to the PSC, so the PSC can record that as a remediation and remove the unsat from your certificate. That is your responsibility. I will repeat, if that happens and you receive an unsat, you successfully complete a PDP or receive a proficient on your the following year's summative evaluation, the school district will not automatically report that to the PSC on your behalf. You will have to make that request. Work with your UniServe director to do that. And then that way, the PSC can record that unsat as remediated so that it can be removed.
thank you, Taya, for that clarification and for going into those details. Thank you so much.
And you're correct, Keisha. Many educators do not know that. It is law. It is on the PSC's rules. It's very important as educators to read the code of ethics and the rules around your certification, how to maintain your certificate as a teacher in Georgia. I'll drop that link in the chat as well.
Okay, and leading this, what is GAE Legal doing to fight back? Restoring your fair dismissal act due process rights. Okay. You know, we've talked about the waivers to make sure that you go to your districts, go to the Department of Education and look at the waivers your district has chosen, because many have chosen to waive fair dismissal acts. But here's one case. NEA GAE lawyers have filed several lawsuits seeking reinstatement of your due process rights guaranteed under Georgia's Constitution. Most recently, Fannin County Charter System, and this was filed in October 14th of 2020. And it was on behalf of a member who was terminated and was not given due process rights. She was not given the right to a hearing because in the charter system and their charter, they stated that they were waiving all rights to, waiving the rights to due process for their employees. They wanted that waived as part of their waiver agreement. Well, most recently, the federal county trial court issued an order agreeing with the GAE that the Fannin County waiver is unconstitutional. The court prohibited the district from enforcing the FDA waiver against any educator who earned FDA protections before converting into a charter school system. It's almost as though those persons that had received those rights prior to the charter school system were grandfathered in. However, this does leave it open to those who come into the charter school system after the due process, after they became a charter school system and did not have the rights previously. So, but we do consider that a huge win. And that was just recently, I think we recently received, when I say most recently, that was in the last couple of weeks, we received that decision. And we filed that October 14th, 2020. So we do consider that a win. And when you ask how important due process rights are, very, very important. As I say, we fought for them. We are continuing to fight for them. And there's something very precious. The due process rights are very precious to educators. And I think it's very important that you be conscious of that. Like I said, when persons like to leave one school system and go to the other, be sure, think through it and try to settle down in one system and get 4 years in there so that you can get those due process rights, and understand that when you go to another system that you have to sign your second contracts before you regain those rights. But they're very, very, very important, and we will continue to fight for those for our employees. Administrators lost due process rights many years ago. Administrators do not have due process rights, and we are fighting. We continue to fight to have due process rights for administrators. We are stronger together, and understand that GAE Legal Services is there to support you. We thank you for your membership, but if you have any issues come up regarding your contract, please be sure to contact your UNISERV director, because as you can see throughout the state with the map before, we have charter schools, we have waiver schools, we have traditional schools. So it is important that you contact your UNISERV director, because the rules are could be different in your district than in another district. I know I have 13 districts, I think now, and all of mine are different. I have a charter district which is very, very difficult to maneuver in right now. So I do want to say thank everyone. I thank you again for coming on. Thank you, Taya. Thank you, Dr. Doe. And at this time, I would like to turn it back over to you, Dr. Doe. Thank you, Taya Donald. She's my rock. I will say that in front of everybody. We work very closely together. We speak every day. We talk on our cases, and I cannot speak highly enough of Taya. So thank you again, Taya. And Dr. Doe, thank you. I'm going to turn it back over to you. You're on mute.
All right, thank you for that wonderful presentation, Wanda and Taya. That was some information that we can certainly use around this time, now that the contracts have begun to be sent to our educators. And I want to leave with an ask. And my ask is that you contact your senator. I'm putting the link in the chat.
Dr. Doe, you're muted again.
Oh, how did that happen?
I don't know.
So I put the link in the chat to organize around Senate Bill 233. So make sure you contact your senator, and don't just contact them about bills that we like, contact them about bills that we don't like. That's more important. Contact them about bills that we don't like. So everyone, thank you so much for joining us this evening, and we hope everyone has a wonderful week. Good night, everyone.
Good night. Thank you, Dr. Doe.